So I'm not normally one to go for these clickbaity bombshell types of takes, but I got to tell you guys, this latest revelation in the Bryan Kohberger case, this is a bombshell. We're going to talk about it. So a whole bunch of new documents were uploaded to the Idaho Supreme Court's website that's set aside for this case. And included in those documents was this rather ambiguous, uninteresting looking objection to the state's motion for a protective order. Now, for context, what is going on here is there is a lot of litigation that is in process dealing with the state's discovery obligations. We've had this motion to compel that's scheduled for Tuesday. It's been pending for quite some time, but basically resulting from the defense making requests for certain information to be discovered that the state is resisting. And of course, as I've mentioned before, the most interesting one of those to me is the genetic genealogy information. We have come to learn that genetic genealogy was used in this case, but we don't yet have much of a picture of when it was used, how it was used, what role that played in the investigation as a whole. Did it confirm suspicion of Kohberger, or did it identify suspicion of Kohberger? So these are really important questions to be asking as we're evaluating how suspicion against him unfolded in the first place. And the state has been very adamantly resisting these requests for information. They don't want to turn over any of this genetic genealogy information. So that's what's led to this motion to compel, and subsequently the state, I think, recognizing that, well, there is a chance that this is going to have to be turned over, is also asking for a protective order, basically to, not require them to have to provide it. So this objection is filed in response to that request by the state. And in it, we obtained some really important new information about the state of this investigation. Although I don't normally like to just read straight through legal documents, it's boring, and I kind of prefer to just summarize and give you my take on it. In this particular case, this is a short summary. It's extremely well written, gets right to the point, so I'm just going to go ahead and share it with you. On November 13th, 2022, law enforcement responding to a 911 call found Madison Mogan, Kaylee Consalves, Xana Kernodle, and Ethan Chapin deceased. Law enforcement later found a K-bar knife sheath placed next to Ms. Mogan on her bed. The sheath was placed button side down and partially under Ms. Mogan and the comforter. On November 20th, 2022, the Idaho State Police Lab in Meridian, Idaho, located DNA on the button of the sheath and performed STR analysis that led nowhere when ran through CODIS, the Combined DNA Index System, other than to show the provider was a male. By December 17, 2022, lab analysts were aware of 2 additional males' DNA within the house where the deceased were located, and another unknown male DNA on a glove found outside the residence on November 20th, 2022. To this date, the defense is unaware of what sort of testing, if any, was conducted on these samples other than the STR DNA profiles. Further, these 3 separate and distinct male DNA profiles were not identified through CODIS, leading to the conclusion that the profiles do not belong to Mr. Kohberger. While this was ongoing, police were investigating many various possible suspects. Many of them provided DNA. At least one had his DNA surreptitiously taken from a discarded cigarette. Many also had their phones taken and downloaded. One area of the investigation had to do with a white sedan seen on a camera located at 1112 King Road, first glimpsed by officers on November 18, 2022. By November 25, 2022, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra is still unknown. A report from an analyst for the FBI dated March 21, 2023 shows the analyst relying heavily on a video of a car heading in the wrong direction and at the wrong time on Ridge Road. The state's latest filing admits that somewhere within all of this, they engaged in investigative genetic genealogy using the DNA taken from the button on the sheath, and now claims that it was due to the use of this technique that it tipped local law enforcement to investigate Mr. Kohberger. It remains unclear what the police first relied on in focusing their investigation on Mr. Kohberger. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. There is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. In essence, through the lack of disclosure and their motion to protect the genetic genealogy investigation, the state is hiding its entire case. So we learned a lot in this very short 1.5-page summary of the facts here, but the key point, the big bombshell that jumps out at me here is in this second to last statement. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. They found no trace DNA in his car. Guys, I got to tell you, this is a big one. Now, I'm already expecting there's going to be a lot of absence of evidence isn't evidence of absence. And that's a perfectly legitimate, logical proposition. But the problem is that when you are dealing with a circumstantial case, part of the strength of the inference that can be drawn from the evidence depends on it being inconsistent with alternative explanations. A lot of times when I'm doing jury selection with a jury and we're talking about the reasonable doubt standard and kind of what that means and how you apply that and stuff like that, I will propose as a working way of understanding how to go about that is, look, if there's a reasonable alternative explanation for a set of circumstances, then you haven't been convinced beyond a reasonable doubt that the state's explanation is the only one that can be true. So being able to draw an inference from a sample of DNA, at this point we understand, believe to be touch DNA, on this button of a knife sheath, you know, the strength of the inference to be able to conclude that that identifies the killer, the person who wielded a murder weapon and committed these murders, is only so strong as the ability of the surrounding circumstances to confirm that inference. And so the problem is, absence of evidence kind of can be evidence when you would expect that evidence to be present under the circumstances, if that would be the reasonable situation given everything else that we know about this case. And given what we know about this case, 4 people were brutally stabbed in an extremely short period of time. This was a messy crime scene. The likelihood of being able to, commit all of these crimes, not leave your own DNA all over the scene, not trace any of the DNA that you are, sorry to be crude here, but kind of waiting in all likelihood, to not track that out to your car, not leave it on your car seats, not have it seep into the carpet, not be tracking it back into your home. This just is not a real highly probable sequence of events. You have to explain, how could this person be so careful to take care of all of these loose ends, but yet be so careless as to just happen to leave that little bit of touch DNA on the button of the knife sheath? So this is not a good development for the state's case at all. I remember when the probable cause affidavit was first released, surely there were mixed reactions to it, but my personal reaction was, there's something there. It's not the strongest case I've ever seen by any stretch of the imagination, but okay, I'd buy that the circumstantial link here to suggest that it's Bryan Kohberger. But the real meat of the investigation was at that point only just going to begin. Now that they have the suspect, they're going to go seize his computers, seize his cell phones, go over this car with a fine-tooth comb, and if there is anything there for them to find, it's gonna wrap him up. That's just going to be such good corroboration that that's where the real meat of the state's case was going to need to come from. Well, what we learned in this page and a half here is that they haven't gotten any of that, okay? Not just the no DNA of the victims that got tracked back anywhere, but also no connection between Mr. Kohberger and the victims. Guys, this sounds a lot like they found nothing on his devices. They didn't find anything on his cell phone or on his tower that show that he was stalking these people, getting into their social media, had any knowledge or connection with them whatsoever. So that's another big, huge piece of the puzzle that's missing here, because we don't know how or why he would have identified these people. What possible steps could he have taken to identify them, locate them, surveil them, plan this attack, go through with the attack, cover up the attack, and just leave no trace of any connection with them at all? That's just very challenging. So what they have, of course, is this circumstantial evidence of his location that is largely created through this ping evidence on his cell phone. But again, the problem with there is, by their own acknowledgement in the probable cause affidavit, it's not a reliable indicator for where he is. They say themselves his phone is pinged off of these towers at times when they have reason to believe he wasn't actually present there. So that doesn't exactly give them a real solid basis to be able to draw inferences about what he was doing at what point, to kind of further solidify this connection that they are trying to build between him and these murders. I want to real quickly talk about some objections that I'm anticipating we will see to my take here, which is that, wow, this is kind of revealing that the state's case is massively falling apart here. Number one, well, he cleaned the car, right? We heard these reports around the time of his arrest, anonymously sourced, of course, that he had been seen out, scrupulously cleaning his car. The problem with that theory is that there is going to be evidence of that. And as this statement is written, it's not just that there isn't DNA, no DNA evidence in the car, it's that there's no explanation for it. So cleaning is typically going to leave some type of evidence. You're going to see that, like, oh, the carpet on the floorboard has been peeled back here because, you would need to be able to get in and clean under that. Blood will seep through, it will leave a residue that can be located. So you'd have to, essentially take most of the car apart to be able to get to that. That's going to leave some type of trace that doesn't appear to be the case here. Likewise, cleaning chemicals. If you're just out there, with a wet rag trying to wipe this stuff up, you're not going to get it all. There's going to be trace there. So it's likely that somebody who is trying to cover up the existence of evidence like this, they're going to use something. They're going to use bleach. They're going to use ammonia. They're going to use some type of chemical to try to destroy any DNA that would remain. That as well is going to leave residual traces. They're going to be able to say, well, we didn't find any DNA, but we sure found a whole lot of bleach residue. That would be circumstantial evidence of consciousness of guilt. So I would expect that the state would be raising that if that's the case. And then the last thing that often comes up in situations like these is you can literally actually see like white marks, okay? When somebody is in there with, again, the wet rag and, just kind of smearing stuff around, no matter how hard you try to like dry it up and polish it and stuff, chances are pretty good that you're not going to get all of the grime and everything out of a, 8-year-old car that has like sifted through the carpet for all that time and stuff like that. You're not going to get it pristine. And so what's left is going to show marks from having, wiped something over it, little smears and stuff like that. It's very common to find. That would, again, be an explanation for why there is no DNA evidence found in the car. But apparently that doesn't exist based on this representation that we're getting in this sentence here. Another objection I expect to see, oh, this is just the defense's version of things. The everybody lies except the FBI defense. Well, I don't buy this for a lot of reasons. Now, certainly, when you're a defense lawyer, you are going to present the facts in the way that is beneficial to your client, beneficial to your position. So you kind of expect there to be a little bit of polemic, a little bit of painting things in a light that is just favorable to your client. And Mr. Logsdon in particular has something of an aggressive style with his writing. I actually like it a lot. I find it very direct, to the point. You don't have any trouble understanding where he stands on something. At the last hearing, the gag order hearing, I actually ran into Mr. Logsdon in the hall after the fact and told him I enjoyed and appreciated his writing style. So yeah, there is a certain amount of, I suppose, flexibility that maybe you should expect when you're reading an argument from the defense counsel. But of course, as we heard, the defense counsel has a duty of candor to the court. You are not well served by misrepresenting the situation to the court, because they're going to find out. This would be a very stupid position to sort of make up out of the blue, because the state is going to be able to come in and correct that and point out to the court, here is the evidence that we have of DNA in the vehicle. Here is the evidence we have of why there's no DNA in the vehicle. So this is incorrect. And now, Mr. Logsdon's credibility as an advocate to the court is completely shot because he made the stupid decision to overstate his case. Because of that, I tend to find this pretty reliable. You don't take a hard position as an experienced criminal defense attorney unless you're able to back it up. So I don't know if we're going to get a written reply from the state before this whole thing goes into the hearing on Tuesday afternoon. I'm going to keep an eye out on it, but certainly, if you hadn't guessed, yeah, I'm going to be there Tuesday afternoon. Was planning on it anyway, but I very much am going to need to see this argument and how this all goes down with my own two eyes. So another possibility there that Mr. Thompson could just be prepared to argue orally why he thinks this characterization maybe is too strong or maybe is inaccurate. But if he doesn't do that, well, then that is kind of what in the law you call an adoptive admission, a situation where you would expect somebody to deny it if that weren't the case. So going to be very interesting to see how Mr. Thompson responds to this allegation in the coming days. This is probably the most critical new information that has come to light in this case since the gag order was initially entered. The fact that there's other DNA, male DNA found at the scene that can't be accounted for, and the fact that there's no other link, none, besides what we've already seen in the probable cause affidavit that links Mr. Kohberger with these victims. None of his DNA on them, none of their DNA anywhere we would expect it to be with this type of a crime. This is huge information, and it really indicates that the state's case is kind of falling apart here. Not only do we just have the basic evidence that was in the probable cause affidavit all the way back at day one, but we're also seeing that PC affidavit itself is kind of starting to crumble. We've got concerns now about additional, investigative steps that may or may not have been taken, problems with how the car was identified. We already knew there was going to be, a hitch in the road with that disclaimer in the search warrant affidavit in Whitman County. I'm not going to let that one go, guys. The whole, we're disclosing this DNA evidence for the court's information, but specifically asking you not to rely on it. There is no legal reason to do that unless you have a concern of illegal activity. You can rely on information that's wrong or evidence that's bad that just happens, you relied on it in good faith, but it just turns out to be incorrect. Police do that all the time. That will still authorize a search. It won't invalidate it. Illegal activity is what invalidates a search warrant. So still more little things that are kind of lurking in the wings, waiting to pop up and potentially cause problems for the narrative that is out here, that Bryan Kohberger is obviously guilty. It must be him. There's a very strong case, and so on and so forth. And so in light of how significant this new information is, I think it's going to be really critical to see in the coming days who in the media reports it and how do they report it? How honestly are they going to be in incorporating this new bit of information into their analysis of the case? I think that's going to tell us a lot about what is really driving the media focus here, an interest in justice or a narrative that's already been predetermined. So I'm going to be watching. Guys, I'm also going to be in court on Tuesday to watch this hearing. No way I'm going to miss it at this point. So I'll be back to let you know kind of what I take away from that process, and continuing to follow up with the other developments in this case. So stay tuned, stick around, and I'll see you in the next one.